Hello and welcome to Module 12, the second part of our privacy discussion. In the last module, we discussed the privacy laws that govern sharing with the government and the general privacy law, the Gramm-Leach-Bliley Act. Rounding out the privacy laws that banks are really concerned with is the Patriot Act and the Fair Credit Reporting Act. So we're going to talk about the Patriot Act first. And the Patriot Act is actually a law that was enacted in 2001 that went in and amended and enhanced some existing laws. And one is the Bank Secrecy Act, which has been around, of course, for a long time, the Office of Foreign Asset Control provisions, and it created the Customer Identification Program. But it was called the Patriot Act. It was after 9/11, uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism. And what this should give you a sense of is that although there is some concern with privacy, a lot of illegal activity involves money, and banks are key conduits for money. And so banks have an obligation under federal law to monitor and report activity under the Bank Secrecy Act and some of these other provisions as part of our war on terrorism and drugs and other bad things. And it's been really, it's been a huge focus, I will say, of the regulators ever since 2001, but even more so now with fintechs and a concern of maybe a lack of sophistication, that things are getting so complicated. And so it's a big area where the regulators really want to see an individual compliance professional in charge. And that is really a big focus of compliance these days, is to have one person who is sort of overseeing it, one person that is held accountable, who then is in charge of developing the program, the employee training, the reporting to management. But in Bank Secrecy Act, it's very important to have really experienced professionals. So the Bank Secrecy Act is focused on anti-money laundering. The Office of Foreign Asset Control actually applies to every individual and every business, and basically says no one can do business with people on this list, these specially designated nationals. But a lot of times in all of these, the risk and the sophistication of the individuals involved impact what is required. And so for large banks dealing with financial transactions, the bar is very high. If you sell your bicycle, you probably don't have to do an OFAC check. But oftentimes when I've dealt with the regulators and they are questioning the Bank Secrecy Act and the anti-money laundering programs, they will say repeatedly, it's not concerned that the bank is going to engage in illegal activities. The concern is that if you have unsophisticated banks or unsophisticated fintechs, they will be taken advantage of. So that is the big emphasis from the compliance perspective, not to weed out illegal acts by financial institutions, but to weed out those who are not sophisticated enough to have strong enough programs to prevent being used by the bad actors. So part of that is knowing who you're dealing with, which interestingly, just as this was becoming such a focus, everything starts going online. Whereas in the old days, you went into the office with your picture ID, now it's all done online. And so you must have some way to identify individuals, name and date of birth, address, some kind of identification number. I'm even seeing more often with account opening, photographing yourself on your phone and sending it to the bank to keep track of you. And so under this required customer identification program, a bank has to have a plan, which they can show to their regulator, as to how they verify IDs, how they keep these records, how they've checked on their customers against the OFAC list. And there's also a requirement that you give your customer notice that we are checking your identity for the purpose of preventing terrorism. And so it's all part of a strong anti-money laundering compliance program. And, you know, some of these, this privacy law and this anti-money laundering, these would all be good facets for a compliance project. If it's of interest to any of you, just let me know. Beyond the basic customer identification program, and if you're a business, needless to say, it's even more difficult because there are beneficial owner rules where you have the business entity, but as we know, corporate entities can come and go in a day. You then have to get live human beings who are the beneficial owners so that you can tell who is controlling these corporations or LLCs. Another part of a bank's obligation is to report any kind of currency transactions of $10,000 or more in a single day. And you have to aggregate them if they occur throughout the day. And again, it's the idea that these are the types of transactions that may signal illegal activity. And particularly if you're interacting in cash, that's what this relates to. And it is going to actually start applying to crypto as well next year. So transactions in cash or crypto. And there's been a lot in the press lately about banks shutting down people's accounts. And someone was indicating that their account had been shut down, and they believed it was because they were bringing a lot of cash to the bank for deposit, and it was just under $10,000. And so it was appearing to the bank, at least, to be fraudulent, although in reality, the individual said they owned a restaurant and the amounts were just getting much lower because there was so much less cash involved. But nonetheless, the threshold has really stayed at $10,000 for a very long time. Another important compliance obligation are these suspicious activity reports. They're called SARS report. And a bank must report a transaction if it is conducted or attempted through a bank. It involves or aggregates $5,000 in funds or assets, and this is in a day. And the bank knows, suspects, or has a reason to suspect, which are pretty broad words, that involves illegal funds, that's obvious, is intended to conduct or hide funds derived from illegal activities, and that seems bad, should be reported, is designed to evade any requirement of the Bank Secrecy Act, that's what BSA stands for, or has no business or apparent lawful purpose. And so if you think about what this means, particularly this last item, it means anytime there's a transaction of at least $5,000, if it does not appear to have a business or lawful purpose, a bank is obligated to report it. And this is if it knows, suspects, or has reason to suspect the transaction has no business or apparent lawful purpose. Well, as I mentioned, banks get in very big trouble if they do not comply with all of this Bank Secrecy Act activity. And so what we have seen is that banks just over-report. And in fact, I looked up some statistics and it said in 2014, 1.6 reports were filed. And in 2022, 3.6 million reports were filed. And so what you see with the larger banks that have a lot of transactions over $5,000, they're just, if it doesn't seem normal, they're reporting it. And so it is an interesting situation where we see, again, banks being a big part of kind of a government function. As we know from our early discussions, banks are a big part of monetary policy. And now we see it where banks are a big part of kind of the war on drugs and terrorism and all kinds of illegal activity. So it is just a huge compliance area for banks. Now, the second big law that we're going to talk about, which we referenced in the last module, is the Fair Credit Reporting Act. It was enacted in 1970 to deal with credit reporting agencies. That seems pretty basic, tells credit reporting agencies what to do because they play a pretty important role. But in 1996, it was amended to have requirements that applied to banks. So prior to 1996, banks didn't have to worry about it. But after 1996, users, which are banks, and furnishers of information, which are banks, also came under the Fair Credit Reporting Act. And then it was amended again in 2004 to deal with ID theft. And so now it really deals with all kinds of activities. But from a bank's perspective, one of the key parts is that to obtain a consumer report, which would be obtained if a bank wanted to extend credit, they must have a permissible purpose. And one, as we see, it can be the written instructions of the consumer. If a consumer applies for a loan, they can authorize the bank obtain their consumer report. In addition, a bank may also obtain a consumer report in connection with a credit transaction involving a consumer, or review or collection of an account that's been extended. So basically, just because a consumer applies for an account, the bank can obtain their credit report at any time during the life of the account. And there are a few others, but really these are the main ones. There are other ones for employment and insurance purposes that we're not going to get into. But the final one used to be very popular, a little bit less so now, but it's pre-screening. Pre-screening was being done extensively at the time that this was enacted in 1996. And those were the offers you get for credit cards where it says you're pre-approved. And it says you're pre-approved because they already got your credit report. Well, that doesn't seem exactly right, but it was a kind of a big deal then. And so the compromise was this pre-screening, which basically says they can't get your full credit report, but they can give the credit reporting agency criteria. This is who we're looking for, and a list. So for example, they'd say, okay, all the OSU students, if they have credit scores in this area and no 90-day delinquencies, we want their names. And then they are obligated to send everyone on that list a firm offer of credit, which basically means we will grant it to you, assuming nothing has changed. And they can verify that. And if it's a mortgage loan, you might have to get, you might have to have a mortgage, obviously, or if it's a motor vehicle loan, you have to have a motor vehicle. But that is how you get those pre-approved offers. They did not get your actual credit report, but they told the credit reporting agency the type of characteristics they were looking for, and your name came back. Now you can opt out of that. If you get one of these notices, it will tell you how to opt out. Or you can go online and it will give you the options for that. Some of the really important provisions in the newer amendments, which create real compliance issues, although they are important, are the duty to correct and update information, the duty of a bank to let a credit reporting agency know if someone has disputed any information, a duty to let the credit reporting agency know when an account has closed, and duties with timelines about what a furnisher, which is a bank, must do if they get a notice of a dispute. And these are the kinds of requirements that are very easy to violate, because it's like, you get a notice, you have, 30 days to investigate and respond. You have X number of days to let the credit reporting agency know. So these are the kinds of requirements that require very detailed compliance procedures and a lot of sort of self-auditing to make sure that they are complied with. Some of the additional items that can impact the banks that are also in the more recent amendments are the fraud and active duty alerts that can be put on a report so that it's sort of closed down for new creditors to look at. Prohibition on a bank selling debt that's been caused by identity theft. So if someone notifies the bank that a particular debt was the result of identity theft, they are prohibited from selling that. That came about because lots of consumers testified in Congress that they were the victim of identity theft, and then they were hounded for collection agencies, and then they convinced them that it was ID theft, and then they sold the debt, and it started all over again. Another important part doesn't necessarily impact banks, but everyone is entitled to a free consumer report. I always encourage everyone to take advantage of that. But then the affiliate sharing for marketing that we referred to in the last model and that we see in the GLBA privacy notice. It used to be under GLBA that a bank could share with its affiliates without limit, but now under the FCRA, a bank or any financial institution must inform its customers if it shares with affiliates for marketing and allow them to opt out. And the risk-based pricing notice is another requirement that requires a notice to consumers if they are being charged higher prices based on their credit report. And so the whole idea here is that if someone's credit report has negative items on it from ID theft, they may never know it because they may just have to pay more. And the idea is that if people have more information, presumably they can see the mistake quicker, they can get it corrected. But does that really work? I don't know. There's a lot of information out there that says there's a lot of errors in credit reports, but the risk-based pricing notice is to inform people when they're getting higher priced credit based on their credit score or delinquencies, so that if those are not in fact theirs, they can hopefully sort it out. But kind of dovetailing with GLBA is to understand what is a credit report. So a consumer credit report, it basically, and it's in the handout that I gave you, you'll see it's very encompassing. Basically all kinds of information, that's collected and gathered for the purpose of extending credit. But what I have on the slide here are the exceptions and what is not, because that is really, as is oftentimes the case, what's more important. Because the definition of consumer report is written very broadly, but then it excludes certain things. And one of the things it excludes is information solely as to transaction or experience between the consumer and the person making the report. So what a bank collects about an individual in their own transactions is not a credit report. And so that is not governed by the FCRA. That's what's important about something being outside the consumer report. Also, the sharing of that information among persons related by common ownership or affiliation, basically affiliates. So what this shows is that a bank can share its transaction and experience with others and with its affiliates. And then it says communication of other information among persons related by common ownership, that's affiliates, if the person is given an opt-out. And that is the basis of the other opt-out in the GLB privacy notice. And so the other information is essentially the credit report information. So the FCRA says you can only share credit report information if you give the notice and the right to opt out. Now, as we talked about in the last module, anytime the default is that everything goes, if you don't opt out, most people will do nothing. And so when you have these required opt-outs, it's in some extent beneficial. Obviously, some people will opt out. That's important compliance obligation, but most will not. And that leads to our preemption analysis here, because unlike GLBA, FCRA typically preempts state law. And so much of FCRA was enacted as a compromise and to avoid 50 state compliance, because the pre-screening and the security freezes and the active duty alerts, all of those are now only regulated at the federal level, which makes it much, much easier. And so oftentimes the reason these things can pass is because there is a preemption provision, as there in the FCRA, that says, okay, it's the federal law. This is the law on this topic. States cannot be more restrictive. So what we were left with was GLBA, basically no preemption, and FCRA, lots of preemption. And so as soon as the states tried to enact stricter privacy laws, which of course occurred in California, which is very pro-consumer, the banks filed suit and said, hey, we think it's preempted under FCRA. And in the first suit, that is what the banks claimed, and that is how the court ruled. Although in that case, there was ultimately a settlement, so the decision was vacated. And the first case involved a local ordinance. Well, sometime after this, the entire state of Chicago passed the California Financial Information Privacy Act. And again, the bankers filed suit and says, hey, to the extent you're trying to restrict sharing among affiliates, that's preempted by FCRA. Because as you'll recall, FCRA has several provisions on affiliate sharing. And so what you'll remember is that GLBA allows unlimited sharing among affiliates, but FCRA has some requirements and some opt-outs. And what California tried to say was that you would have to opt in. That's not obviously going to happen. So ultimately, this case went up and down the Ninth Circuit with remand and reversals. But the bottom line is that the outcome is that the FCRA preempts state laws that restrict the sharing of financial information among affiliates. And I think that's a large reason why we did not see a lot of states after Vermont and California enact additional privacy laws. Now, we are currently seeing a lot of privacy laws being enacted that are general privacy laws, which kind of sweeping the country. But what's very interesting is that most of these, except for California's partially, exempt entities that are subject to GLBA. So GLBA is really helping the banks now because they don't have to comply with these very broad privacy laws that are currently being enacted in the states. Now, California was a little different because it only preempts information subject to GLBA. So it's a small nuance that creates, again, compliance nightmare. But that's really where we're seeing the growth in privacy laws, not on the financial privacy side, but the general privacy side. So if you have any questions on this topic, I encourage you to reach out or put something in the discussion board and we can discuss it there. So thank you.